Good morning and welcome to our program on severance plans, where we are going to focus on ERISA, the Employee Retirement Income Security Act, and a specific area of the Internal Revenue Code that affects severance plans. My name is Ken Ginder. I'm a member of Verrill's Employee Benefits and Executive Compensation Group. I've been with Verrill since 1997, and I'm joined today by my colleague, Sam Baldwin, who is also a member of the EBEC group. And Sam has been with us since 2016. So before we get into the program, I have a few housekeeping items to tell you about. First of all, this program has been approved for one SHRM credit, and you will find the certificate in a link in the chat room. Second, we would love your questions. If you could put your questions in the chat room. We intend to address those at the end of the program. So if you could use chat rather than Q&A, that would be great. Third, the slide deck will also be available through a link on the chat, through the chat function. And then the recording, we are recording this program. So if you'd like to see this program later, you'll be able to get that in a few days. And then finally, in terms of housekeeping, this program today is one in a series of programs that Verrill is putting on the third Thursday of every month. And so just want to let you know that next month, on November 18th, we will have the next program, and that will be a program with three of our attorneys, Tawny Alvarez, Emily Coombs-Waddell, and Liz Johnson, and they are going to be talking about religious accommodations in the workplace. So that should be a pretty interesting program. So hopefully you'll be able to join us for that one as well. So with that, let's get to it. So we're talking about severance plans. So is your severance plan, policy, or practice subject to the Employee Retirement Income Security Act? What we find often is that employers will maintain a formal or an informal policy program that they offer sporadically or intermittent basis, or sometimes they'll offer a program that is for a limited period of time to downsize, and they don't realize that their plan, their severance plan, their severance policy program or practice is subject to ERISA. And a real life example of that is when we do mergers and acquisitions, there'll be due diligence associated with that. And of course, we will always ask, do you offer a severance plan? And the answer will many times be, no, we don't offer a severance plan. But then you dig a little deeper and you find out, well, they actually do offer severance, and they offer it on a regular basis, and they use a formula to determine whether or not the amount of the severance. And suddenly we conclude they actually have an ERISA plan that they didn't realize they had an ERISA plan. And there are consequences to that we will be covering later in later slides. So we just want employers to be mindful that when they offer severance, it may be subject to ERISA. So how do you know if you have an ERISA severance plan? Well, there's a two-part test involved. The first part comes straight from the statute, and it requires an analysis that goes like this. Would a reasonable person be able to ascertain the existence of intended benefits and intended beneficiaries? So would your employees, if you're a reasonable employee, be able to ascertain whether or not there's a benefit? Would they also be able to ascertain a source of financing, from the employer? Is the employer going to pay severance? And then third, is there a procedure? Could they ascertain there's a procedure for receiving this benefit? So two important things about this test, this part of the test, is you can see that it's very fact specific. So we usually, it's based on the facts and circumstances of your particular situation. So you really need to look at the facts and circumstances. And then there's a second part to the test. And this part is really comes from the Supreme Court. And the Supreme Court has said, in addition to those things, there has to be an ongoing administrative scheme for there to be an ERISA plan. And they held that, they made that the rule in 1987 in a case called Fort Halifax Packing Company. And in that situation, there was a state law, and that state law required employers who were shutting down a factory to pay severance to their employees in a lump sum. And the court held that in that type of situation, where there was a single event and there was a single payment, there was really no administrative scheme. So this situation didn't constitute an ERISA plan. So since 1987, you need this administrative scheme. And you can see, once again, this is sort of a facts and circumstances situation analysis of whether or not you have an administrative scheme. Two points about that case that I just want to note for you. First of all, it originated in the state of Maine, so I had to, a little shout out that Maine has played an important part of ERISA severance plans. And second of all, our very own Dick Moon in the Labor and Employment Group actually was part of that case and filed an amicus brief with respect to Fort Halifax. So just a few shout outs there. So you can tell from the test as to whether or not you have a severance plan, what we're really looking for are characteristics. And I'll walk through these characteristics, but if I had to summarize for you, the more complicated your severance program, so the more detailed the benefit formula, the more detailed the criteria as to who can and cannot participate, the more likely you're going to have an ERISA governed plan. So what we would look for, are there specific procedures in place? Is there a policy that defines who's eligible? Is there a benefit formula? Is there an ongoing program? Would people know where to go to get this benefit? Does your HR department sort of administer this thing? Do you do this on a regular basis? Or is it just a one-time thing? Are you generally providing employees who satisfy criteria this type of severance benefit? And then finally, how are the payments made? Are they paid in just one lump sum, one and done, or are they paid out over a period of time, which is very common for a severance plan? We'll pay you X amount over X number of months based on often years of service. If those types of characteristics are present, you probably have an ERISA governed plan. On the other hand, if you just have an ad hoc system, once in a while you give severance, there's really little rhyme or reason as to why the severance is paid. There's no definite procedure as to how someone would get severance. And if it's a one-time payment, you probably don't have an ERISA governed plan. So again, it's a fact-specific type of analysis, but that's what we're looking for to see whether or not there is an ERISA governed plan. So assuming there is an ERISA governed plan, there's another step in the analysis. And the question is it a pension benefit plan or is it a welfare benefit plan? And at first glance, you might say, how could a severance plan be a pension benefit plan? Well, it could, because a pension benefit plan includes an arrangement where it results in a deferral of income for an extended period to or beyond the termination of employment. And if you think about many severance plans, they start paying exactly when you terminate employment over a period of time. For example, $1,000 a month for 12 months or 6 months. It starts to look a lot like a pension benefit plan. The problem with that is that pension benefit plans, which include 401k plans, by the way, include very complex rules around participation, benefits, vesting, and funding. And most employers want to avoid those rules, particularly funding. Most severance plans are not funded. They're just paid from the assets of the employer, the general assets of the employer, and that's how they want it. no, most employees would not want to be subject to the pension benefit rules. They would much rather be subject to the welfare plan rules, which don't impose those strict requirements. So how can you make sure you're not a pension benefit plan? Well, thankfully, there are regulations that address this very question. They provide a safe harbor. If you comply with these 3 requirements on this particular slide, then you will be deemed to be a welfare benefit plan and not a pension plan. And they're not that hard to comply with in most instances. You just have to make sure that the triggering event is not the employee's retirement, which is, of course, what happens in retirement type plans. The total payments have to be limited, basically limited to 2 times the person's compensation. And third, you have to limit the time period for the payments. It can't be more than 24 months from the time they terminate employment. So if you satisfy these 3 requirements, you will be an ERISA plan that is a welfare benefit plan, which is where most employers really want to be. So once we've determined whether that you have an ERISA plan, that it's a welfare benefit plan, what are really the consequences of that? Well, the primary ones are listed on this page. Okay. First of all, you need a plan document. ERISA always requires a formal plan document. So you need something in writing that describes the benefit. That's a basic tenet of ERISA. I just want to stop because there's often confusion around that. The fact that you don't have a plan document doesn't mean that you don't have an ERISA plan. You can't avoid ERISA by simply not having a plan document. If you have an ERISA plan, but you don't have a plan document, what you have is a violation of ERISA. You don't get out from under ERISA. Often employers will think, oh, there's nothing in writing. You need something in writing. It must not be an ERISA plan. That's not really how it works. If you're an ERISA plan, you must have the document. If you don't have the document, you're in violation of ERISA. In addition to the plan document requirement, there are ERISA's basically notification provisions. The first are notification of participants, and we do that generally through the summary plan description or summaries of material modifications. So you would be subject to the SPD and SMM requirements to let participants know what the severance benefit is. In addition, you have the notification type requirements to the government, and those are satisfied through the annual Form 5500 reporting requirements. So you have participant disclosure requirements, government disclosure requirements. And then, of course, you are subject to ERISA's fiduciary requirements. And there are basically 4. There's the duty of loyalty. So once you're administering this plan and you have your fiduciary hat, you have to administer it for the exclusive purpose of the participants. And you can't really have your employer hat on. You need your ERISA fiduciary duty of loyalty hat on. You have to administer it in accordance with the ERISA duty of care requirements. So you need to be prudent when you're administering this plan. Often we use a prudent expert rule. So if you don't know the answer to a question, you need to find somebody who can help you answer it. So there's the duty of care requirement. And then there's the duty to follow the written plan terms, which of course is just a fundamental tenet of ERISA. There's also, ERISA imposes yet another duty about diversifying assets to avoid large loss. That really doesn't apply in severance plans because severance plans are unfunded, but that is, I just wanted to make sure I had all 4 duties up there, but that 4th one will typically not be in play most of the time with severance plans. So if you have an ERISA plan, you're subject to these tenets of ERISA, but there's an exception for top hat plans. if you have a plan that is for a select group of management or highly compensated employees, you can have what we call a top hat plan, which can be exempt from many of these requirements. So we would also have to look who's benefiting under the plan. Is it a top hat plan? Do we get out from under most of these requirements? So with that, we'll move on to the next slide, and I think Sam's going to take this one.
Yeah, so Ken told you to look at all of the severance benefits you might be offering, determine whether you may have a plan, and how to determine whether that plan might be subject to ERISA, and then provided an overview of what that means, what ERISA requires you to do if your plan is subject to ERISA. And now I get to present this scary slide about what happens if you then violate those terms, those requirements of ERISA. And by far the most likely issue to come up of the items on this slide is failure to file Form 5500. If you have a plan that's subject to ERISA and you don't realize that it is, you won't know that you are required to file a Form 5500 with the Department of Labor every year. And the penalty for failing to file is fairly steep. These just went up in 2020. It's now $2,259 per day that the form is late, and there is no cap on that penalty. So you can imagine if you miss that filing for several years, you have one that's, 4 years ago you were required to file a Form 5500, those penalties can accumulate and become pretty large. There's also a separate set of IRS penalties for failing to file a Form 5500, but generally the two offset. Thankfully, the Department of Labor offers a delinquent filer program for the Form 5500. So if you miss a filing, if you're late with a filing, you can file the Form 5500 through the delinquent filer program and pay a significantly reduced penalty. I mean, this can be the difference between a few $100s and tens of thousands of dollars. So I guess a takeaway from this presentation is if you miss the deadline on a Form 5500, severance plan or not, file the Form 5500 through the delinquent filer program. Don't just file it late. Don't cross your fingers and hope nobody notices. The delinquent filer program is your friend if you blow the deadline on a 5500. Another potential source of penalties is failing to provide participants with a summary plan description. So Ken laid out that an ERISA plan is required to have a summary that describes the terms of the plan that gets distributed to participants. And if a participant asks you for a copy of the summary plan description and you don't provide it, maybe because you didn't know the plan was subject to ERISA and you don't have one, the penalty is $110 per day that you fail to provide that employee with the summary plan description. Breaches of fiduciary duty can also result in liability. So Ken laid out those 4 duties under ERISA. And if you violate any of those rules, if you, fail to make decisions solely in the interest of participants, fiduciary breaches can result in liability directly to individual employees or former employees. And the DOL can also bring enforcement actions, and the DOL will tack on a 20% additional penalty on top of anything they recover. An important note with breaches of fiduciary duty is that the individual fiduciary who caused the breach can be held personally liable for the harm that results from that breach of fiduciary duty. Prohibited transactions. So both ERISA and the tax code have sets of rules that govern who's allowed to interact with the plan, specifically who's allowed to be paid for providing services to the plan and who's allowed to interact with money that belongs to the plan. If you are not aware that those rules exist, that makes it, not aware that those rules apply to your plan because you're not aware that it's an ERISA plan, that makes it much more likely that you're going to stumble into a violation, and there are both excise taxes and DOL penalties associated with prohibited transactions. I think those are less likely to be an issue with a severance plan than other benefit plans, because you don't typically have plan assets, you don't have an account sitting there full of money, but those are rules to be aware of if you have a plan that's subject to ERISA. This last bullet I almost didn't put on there. This is extremely unusual, but ERISA does have criminal provisions. So if you have just an extremely egregious, willful violation of ERISA, individuals can face up to 10 years in jail and fines of up to $100,000, and a company that faces ERISA criminal violations can be hit with fines of up to $500,000. So with all of that, with all of those significant consequences, and with all of the requirements that Ken laid out for what you need to do if you're subject to ERISA, we still often recommend that in close situations, employers take the position that their plan is subject to ERISA. And when Ken was describing how to determine whether your plan is subject to ERISA, he talked about the fact that it's a fact-specific inquiry. And so it can frequently be unclear whether or not a particular severance plan satisfies all those requirements to be an ERISA plan. And in those close circumstances, we often recommend that employers treat their plan like it's an ERISA plan, satisfy all of the ERISA requirements, and take the position that this is an ERISA plan. And the reason for that is, I guess there's two reasons. One is that there's no penalty for complying with ERISA when you didn't have to. And the other is that there are real advantages to an employer of having the plan be ERISA covered. And the situation where that most often comes up is in the event of a dispute with a former employee. So when you're talking about a severance plan, you're talking about an employee who has terminated employment. Often that's going to be an involuntary termination, so you might already be looking at a tense situation. And that former employee believes that they're entitled to what might be a fairly significant amount of money, and the employer disagrees. And so I think of all the benefit plans, severance plans are especially likely to lead to contentious situations and potentially lawsuits. And in the event of a dispute with a former employee, there are some advantages of having that severance plan be covered by ERISA. So one of those is that ERISA requires the plan to have specific claims procedures. And what that means is that the plan lays out a process for an employee who believes they're entitled to a severance benefit to file a claim with the employer stating that they believe they're entitled to a benefit. The employer then is required to respond with an explanation of why the employee is not entitled to a benefit. And then there's an appeal process for the employee. And there'll be a time limit on filing that appeal. The employee then explains why they think they are, and the employer will then issue a final determination. And that has a couple benefits. One is that we often find that these disputes can be resolved simply through the process of the employee expressing why they believe they're entitled to a benefit, and the employer providing a clear written explanation of why the employer doesn't think that the plan entitles that former employee to a benefit. Just providing that explanation can often diffuse these situations. The other benefit is that it's a specific process with specific requirements and time limits. And if the former employee doesn't follow that process, if they don't exhaust those claims procedures, then they can't bring a lawsuit. The claims procedures can also set out a limitations period for lawsuits. So the claims procedures can set a deadline for when the employee needs to bring suit after exhausting the ERISA claims procedures. And often that deadline is going to be shorter than whatever the statute of limitations under state contract law or whatever else might apply to limit the time period where the former employee can bring suit. You can also use the claims procedures to set a forum for lawsuits. So you can require that any lawsuit seeking benefits under the severance plan, let's say you're an employer that's based in Massachusetts, you can say all suits need to be brought in a federal court in Massachusetts. And that can help avoid situations where a Massachusetts employer is trying to litigate a suit in a court in California. Another advantage of being an ERISA covered plan is preemption of state law. So what this means is that if the plan is subject to all of the ERISA rules, any state law rules don't apply to that plan if those rules would affect how the employer administers the plan. And so if you operate in multiple states and those states have rules that would govern the operation of your severance plan, you don't have to worry about those different state laws, and instead you just have to focus on complying with the ERISA requirements. And in the context of a dispute with a former employee, preemption of state law means that the employee can't bring claims under state breach of contract laws or wage and hour statutes, and that it limits the scope of claims that you might face. But also state laws often have punitive damages or statutory damages that are designed to be a penalty, and ERISA doesn't provide any of those things. Preemption of state law also has the effect of resulting in all lawsuits needing to be in a federal court. So a lawsuit around an ERISA covered plan has to be brought in a federal court. And some people believe that federal courts are more favorable to employers than state courts. I have no idea if that's true, but some people believe it is. Federal courts also have a consistent set of procedural rules. So you always know what you get and how the process is going to go in a federal court. Some states have just unreasonably arcane procedural rules. So depending on what state you end up in, if you're not familiar with how to litigate in that state, it can be a problem. And then the final advantage to talk about is that if you do end up in a lawsuit and your plan has a provision that says the employer as the plan administrator has the authority to interpret the provisions of the plan and to determine who's entitled to benefits, then the court is going to give deference to the employer's decision as to whether the employee was entitled to benefits. So if you have what might be a close case, maybe it's not 100% clear whether or not this former employee should have received a benefit under the severance plan, the court is going to give deference and follow what the employer decided. If you are not subject to ERISA, or you don't have the right language in the plan, then the court is going to look at the facts, they're going to look at the terms of the plan, and the court's going to make their own decision about whether or not that former employee should have been entitled to a benefit. And so for all of those reasons, and the fact that it can be somewhat unclear whether or not a particular plan is subject to ERISA, we often find ourselves recommending that employers take the position that the plan is subject to ERISA, adopt a formal plan document, file your Form 5500, and comply with those rules.
Thanks, Sam. And just the advantages are very substantial. I would say earlier this week, we had a client provide us with a letter from a particular state's attorney general asking what our position was with respect to a situation under their law. And our position is going to be that your law is preempted by ERISA. And so this is really helpful, particularly if you have employees in multiple states. That preemption component of ERISA is very helpful to employers. So, but we're going to switch gears right now and move from the ERISA requirements and benefits to the Internal Revenue Code. And in particular, Code Section 409A, because it can impact severance too. So for Code Section 409A is the federal law that really governs non-qualified deferred compensation. And I think the history of 409A is informative and will help you think about it. 20 years ago last month actually, Enron, the energy company in Texas, imploded. And what happened is, as it was going into bankruptcy, there were a number of executives that had so-called non-qualified deferred compensation. That's compensation that is deferred outside of a 401k plan, which is qualified, or a pension plan. It's non-qualified. And there are very strict rules around qualified plans as to when you can get your money out. And what happened in the Enron case was many executives saw, they had access to information. They could see that the company was going into bankruptcy, and they pulled their non-qualified money out. And the shareholders were left with nothing. And many of those shareholders were rank and file employees who had employer stock in the 401k plan. So they got nothing, and these executives got millions. Congress saw that and really didn't like it and reacted with Code Section 409A, which now regulates non-qualified deferred compensation. In particular, it limits the time and form of payment of this type of compensation. So moving to severance plans, you might say, well, how would 409A apply there? At first, I'm not sure it was really thought that or realized that 409A would apply to severance plans. But 409A is quite broad and expansive. And it's clear now that it can apply to deferred compensation. There could be deferred compensation under a severance plan, unless an exception applies, and Sam's going to talk about those exceptions. So it's clear that severance can be a form of deferred compensation and subject to 409A. So what you really need to know is, what is deferred compensation? And it's a very simple concept. It's a promise or a legal right, basically, today to receive a payment in a future tax year. That's deferred compensation. I promise you in 2021 that I'll pay you in 2022. Fundamentally, that's deferred compensation if you have a legally binding right to it. So apply that to a severance plan. Many severance plans are designed such that you're going to be receiving payments over a period of time. The reason for that is usually because severance plans are thought of as a bridge from one employer to your next employment. So you're going to be terminated involuntarily, typically, and we want to give you some support to your next job, basically, is how severance often works. It's a bridge to the next thing. And so if you had a severance plan like that and you terminated someone in November, and the terms of the plan provided for them to get X dollars over the next 6 months, you can see they would get paid in December of 2021, and then they'd get paid in 5 different months in 2022. That would be deferred compensation, a promise today to get paid in a different tax year. That's a common severance design, and at first blush would be subject to 409A. Another design would be a lump sum payment immediately at termination. So if, using the same example that I had, if you terminated someone in November and you paid them before the end of December, the term said we're going to pay you by December 31st, and we do so, then you wouldn't have a deferral of compensation in that situation. So it sort of depends on the design, but clearly 409A comes into play, and you have to be mindful of it whenever you're talking about severance. So Sam is going to talk about the exceptions to Code Section 409A that might apply to your severance?
Yeah, so Section 409A is a famously complicated tax provision. Unless you are an executive comp attorney that works with 409A all the time, to the extent you're familiar with 409A at all, it's probably just knowing it as that provision that you really hope doesn't apply and that you don't have to deal with. It's tricky, and the consequences of failing to satisfy 409A can be pretty severe. So we are going to talk in a bit about how a severance plan can comply with 409A, but we're going to focus on how to make sure your severance plan does not have to comply with 409A. So there's two exceptions that we're going to focus on. And an important overall note with both of these exceptions is that neither of them apply unless your severance plan only provides benefits on an involuntary separation from service. So there are some exceptions to that, and we'll talk about some of them. But in general, these exceptions to 409A they don't work if there's a benefit provided to employees who voluntarily terminate employment. So the first exception we're going to talk about is the safe harbor rule. So 409A has a safe harbor rule built into it. And if a severance plan fits within the safe harbor, then it is not subject to 409A. And this first bullet is the point I was just making, that the plan needs to provide benefits only on an involuntary termination of employment. The exception here is for a window program. So I think I mentioned these earlier, but in the context of a reduction in force, it's not uncommon for an employer to say employees who voluntarily terminate employment during this period of time will get this severance benefit. And a window program like that can fit within this safe harbor for severance plans, unless you stack a bunch of those windows end to end and it starts to look like an ongoing program, not a true window. But in general, if we're talking about an ongoing benefit plan, it needs to be based only on involuntary termination of employment. The safe harbor also has a cap on the benefit that can be provided under the severance plan. It's a fairly generous benefit, or a fairly generous cap, but it's 2 times the lesser of the employee's annual salary or the annual compensation limit for retirement plans under the code, which in 2021 was $290,000. So the cap under the safe harbor is twice the employee's annual salary, unless the employee makes more, unless twice the salary is more than $580,000, in which case the cap is $580,000. And unless your severance benefit provides less than that amount, then you're not going to be able to meet the requirements of the safe harbor. And then finally, payments have to be made under the plan no later than 2 years following the calendar year in which the employee was terminated. So for example, employee terminates employment in June 2021, all payments under the severance plan have to be provided by the end of 2023. And if your severance plan provides benefits over a longer period, if it pays benefits over 5 years or some indeterminate period, then it may not qualify for the safe harbor, and you may be subject to 409A. So the other big exception, it's a little bit narrower than the safe harbor, but it's often a severance plan will fit within this, is what's called the short-term deferral exception. So it's another provision in 409A that says that benefits that meet this short-term deferral exception don't have to comply with 409A. So the first bullet is a full statement of the rule. It's got a lot of little complicated moving parts. It becomes much simpler when we apply it to a severance plan. So the basic rule here for a severance plan is that all of the benefits under the plan, all of the payments need to be made by March 15th of the year after the year the employee terminates employment. So employee terminates employment in June 2021. All of the benefits under the severance plan need to be paid either in 2021 or by March 15th, 2022. And if all of the payments are made by then, you qualify under the short-term deferral exception and you don't have to worry about 409A. As I mentioned before, this only works if the benefits are provided only for an involuntary termination of employment. There are some circumstances under which a voluntary termination could qualify if very specific requirements are met, but we're not going to worry about that. In general, these need to be benefits based on an involuntary termination. One place where the short-term deferral exception can trip people up is in the context of severance plans that require the employee to sign a release of claims, age discrimination claims, other employment-related claims that the former employee might have, which is a good idea. And we do recommend that severance programs require the employee to sign a release. But if, for example, the severance plan is set up so that it says you'll be entitled to your benefit within a reasonable time following execution of a release of claims, and the employee takes long enough to sign that release that it pushes you past the short-term deferral exception, now all of a sudden you might have problems under 409A. So the advice here is to remember to account for the time to get that release signed when you're thinking about whether or not you might have issues fitting within the short-term deferral exception. This could look like setting up the plan to say you'll receive your benefit if you sign a release within 60 days of terminating employment, right? Because that puts you in a situation where even if the employee terminates on December 31st and they take their whole 60 days to sign the release, it's still going to put you in early March, which leaves you some time to get that payment made before you lose the ability to rely on the short-term deferral exception. If you are not able to meet either of those exceptions and you've got deferral of compensation under your severance plan and you're subject to 409A, all is not lost. It's not impossible to comply with, and in the context of a severance plan, it is maybe less difficult to comply with 409A than in some other contexts. This is an extremely high-level overview of what 409A requires, specifically in the context of a severance plan. And as we talk about it, you'll see that most severance plans are going to get a lot of the way towards compliance. So the first requirement is a written plan document, which you're going to have already because your plan, if it's subject to ERISA, is required to have a written plan document. The next requirement is a specified payment date, schedule, or event. This is terms that define when the payment is going to be paid and what triggers payment and the schedule on which payments are going to be made. Is it going to be a lump sum following termination? Is it going to be equal payments over the course of 3 years? Is it 24 monthly payments? Whatever it happens to be. And most severance plans are going to have those provisions anyway. Right? That's a key part of offering a severance benefit, is defining what the benefit is and when you're going to get it. The third bullet is a set of provisions that might not be in a severance plan unless you are aware that you need to be complying with 409A. And those are restrictions to changes on the time and form of payment. So in general, what this looks like is prohibitions on the employee's ability to accelerate payments. Their ability to say, okay, I know that the plan says I'm going to get paid over the course of 24 months. I'd actually like to receive all of my benefits now in a lump sum. if the employee can accelerate the payments and get them sooner, you're going to have issues under 409A. And so the plan needs to have a specific prohibition on that acceleration. And then the other set of restrictions on time and form of payment is restrictions on the ability to electively defer payment. So this is the opposite, right? This is the benefit is supposed to be paid in 2021. Does the employee have the ability to say, no, I'd actually like to be paid in 2022? Can the employee elect to defer their payments to later tax years? And 409A is going to require certain restrictions on an employee's ability to defer those payments. I'll kick it back to Ken to talk about what happens if you don't do that.
Yeah, so we've been discussing how you can comply with 409A, and Sam mentioned it's a famously complex set of rules. It's actually pretty darn easy to violate 409A. And so how can you violate it, and what are the consequences of violating 409A? You can violate 409A in basically two ways. First is you operate your plan in a manner that isn't consistent with Code Section 409A. So if you allow somebody to accelerate the payment when they shouldn't be able to, right? So it's sort of like the Enron thing that we're trying to avoid. They accelerated the payments and got the money out before the whole ship sank. So you can have an operational failure. You operate it not in accordance with 409A. Or second, Sam said, you must have a plan document for 409A. Your plan document doesn't comply with 409A. It says you can do something you shouldn't be able to. It allows that impermissible acceleration. So either way, you have a violation of 409A. And if you have a violation of 409A, what happens? Well, some significant and adverse tax consequences happen to the employee, okay? So this is the employee who is going to be affected by the things I'm about to describe. First of all, the employee will have immediate inclusion of all the income that they thought they were deferring to a future year. They thought they weren't going to have tax due. The amounts that were deferred they don't come due, they become includable in income. Now that means you're going to put it on your tax return. They're going to put it on their tax return. Just a special note here, it's included on their tax form, but they still might not have a right to receive the cash. The cash might be due. I might have promised to pay you in a couple of years. You have to take it into income this year, but I'm not paying you still for a couple of years. That can happen. So you have a tax obligation without the money to pay the tax. That can be a big problem. So there's immediate inclusion of income. In addition, there's a 20% penalty on top of the regular income tax that they will owe. So that's pretty significant. And then third, there's another type of tax, and it's this interest-based tax. And what the interest-based tax does is it tries to replicate what the underpayment interest you would have owed to the government would be if the amount were due in the first year it were deferred. So it basically sets up this rubric. It assumes the amount was due in the year you deferred it. Could be a while ago. And then it figures out, oh, but you're paying it today. Of course, when you pay taxes late, the government charges you an underpayment penalty, interest. So it takes that underpayment rate and it applies it to the amounts to replicate what would have been owed, plus it adds a 1% penalty. So these three things can have very adverse consequences to the employee. And that's why you must be mindful of 409A whenever there is the opportunity for deferred comp, and that's definitely the case with severance plans. It doesn't end there. This slide is really about the employee, but if you didn't realize, but there's a component for the employer too, an adverse component. If you didn't realize you had a 409A violation as an employee, if there is a 409A violation, the employer is supposed to report that to the government. So it's not like it goes unnoticed. It's actually on the W-2 for the employee, front and center. But if you didn't know that you had a 409A plan, you probably didn't know that you needed to report it on the W-2. So now the employer has an incorrect reporting, they have reporting problems. There's also withholding requirements for income taxes. And again, if you didn't know you had a 409A covered plan, you probably didn't know you had a 409A problem, you probably didn't do the proper withholding. So the employer has its own problems too if we have a 409A violation and they weren't aware of that. So those are the pretty significant consequences under 409A, tax consequences. So with all of that, what would we advise? Basically 3 steps. First, inventory your severance plans, policies, practices. Do you pay severance? Yes or no? If you do not pay severance ever, you're sort of at the end of the analysis you've done. But if you do, then you need to determine whether that is an ERISA governed plan that you have and whether it's a 409A covered plan. And you could have a situation where your severance is subject to ERISA, but there's no 409A component. You could have the opposite of that too. You could have something that's subject to 409A, but not maybe subject to ERISA. So you need to make a determination on that. And as Sam said a little earlier, if it's a close call, because these are really based on facts and circumstances, you're probably, in many cases, the prudent path forward is to treat it as an ERISA governed plan and a 409A governed plan. As a practical matter, it's often a lot easier, simpler to determine whether it's subject, whether you have a 409A covered situation or not. The ERISA one is a little more difficult, but it's if you look at the whole thing and it's not completely clear, you're probably better off treating it as an ERISA plan. And then the third step is if you have that ERISA 409A type of situation, you need to put in place the policies to administer it properly. You need to have the program in writing, you need SPDs, you need people distributing those SPDs, you need an administrator, you need the fiduciary needs to be aware that there is this plan and that they need to operate it in accordance with ERISA. There's a whole set of things, policy, there's a whole infrastructure that you need to put in place. Infrastructure is maybe too large, it's probably not that big of a deal, but you need to know that you have these things and put in place the systems and policies to administer it properly. So with that, we would take any questions you might have. Sam, I'm looking in the chat room here. I don't see any questions there, but I do have a question that I'd like to pose, and I'll pose it to Sam. So, who ultimately decides whether a plan is an ERISA governed plan?
Yeah, so in general, ultimately, that's going to be a federal judge, right? So the situation in which a real final determination about whether a plan is covered by ERISA or not is most likely to be in the context of a lawsuit over benefits under the plan. And the first step in that lawsuit is going to be the employer saying, this suit should be in federal court and all of these state law claims should be dismissed because this is an ERISA plan. And then the judge making a determination about whether or not the plan satisfies the requirements to be covered by ERISA.
I see a few comments in the Q&A section. First of all, someone said the chat is disabled, so I just asked the people sort of in the background here at Verrill to see if they can enable it. And the question was, could we get the slides? They are in the chat. They're a link in the chat. So once that's straightened out, that should be taken care of. Another question I have has to do with whether an employer, it has to do with Forms 5500 and who is a participant in a severance plan. So these are the facts. You have an employer, they have 150 employees. They have a severance plan that is not funded, and it provides severance to people who are involuntarily terminated, and it provides a benefit that's calculated and paid over, it's calculated based on prior compensation, and it's paid over a period of time. And so we think it's an ERISA governed plan. And yet, I'll just use a year. In 2021, no individual was terminated from the employer, and so no one received severance under the plan for 2021. The question is there a Form 5500 filing requirement in that situation? Now, Forms 5500 and the plan qualifies as a welfare benefit. So, okay, who has to file a Form 5500? What welfare benefit plans have to file a Form 5500? Well, unfunded welfare benefit plans that provide benefits that have 100 or more participants are subject to the 5500 filing requirement. In our situation, no benefit was paid. And you can see severance is a funny thing because it's often paid like in the middle of the year. And these rules, if you read the 5500, talk about participants on day one. So you could lay off the whole workforce in the middle of the year and nobody was getting severance on the first day of the year. Anyway, the short answer to that question is we would say that you do have to file a Form 5500 because ERISA defines a participant as anyone who is or could become a participant. And in my situation, all 150 employees could become participants in that year. They didn't, but they could become. And so we would advise you to file a Form 5500. That's the position the DOL would take in that situation.
So it looks like the chat, I think, should be enabled. So please feel free to enter any questions in the chat that you might have. In the meantime, Ken, could you talk a bit about when severance benefits that are part of an employment agreement with a specific employee might turn into an ERISA plan? So I think probably the situation to talk about is where an employer has multiple employees with severance benefits, but it's always done through employment agreements as opposed to, a separate document.
In that situation, you could have an ERISA plan. I mentioned early on that if the employer is providing severance over and over to different employees, but not necessarily under a plan document, you could have an ERISA plan. So you could have an ERISA plan in that situation. The fact that it's in an employment agreement doesn't mean it wouldn't be an ERISA plan. But I think as a practical matter, if it's in an employment agreement, that's probably someone who we would consider a select part of management or a highly compensated individual. And so what we probably really have is a top hat plan that would be exempt from many of the ERISA requirements. I don't see any other questions, and I think it's now 10:30, so we're sort of at the end of our hour. So unless any other questions come along, I should move to the next page. So if you have any other questions, feel free to contact myself or Sam. Our contact information is at the back of the materials, which are of course now available on the chat link. And so thank you for your time. We really appreciate it, and we hope to see you at the next one on November 18th, when Tawny and Al talk about religious exemptions in the workplace. So thank you all. We really appreciate it.